Preet Verma and this is video of meaning and types of international law. So first of all, the question is, what is the meaning of international law? Also known as law of nations, international law is the set of rules, norms and standards generally accepted in relations between nations. It establishes normative guidelines and a common conceptual framework to guide states across a broad range of domains including war, diplomacy, trade, and human rights. International law aims at the practice of stable, consistent, and organized international relations. On the other hand, the relationship and interaction between a national legal system, that is municipal law, and international law is complex and variable. National law may become international law when treaties permit national jurisdiction to supranational tribunals such as the European Court of Human Rights or the International Criminal Court. Treaties such as the Geneva Conventions may require national law to conform to treaty provisions. Now let's discuss the historical background of the organization of international law. Now the origins of international law can be traced back to antiquity. Among the earliest examples are peace treaties between the Mesopotamian city-states of Lagash and Umma, approximately 2100 BCE, and an agreement between the Egyptian pharaoh Ramses II and the Hittite king Hattusil III, concluded in 1258 BCE. Interstate pacts and agreements of various kinds were also negotiated and concluded by polities across the world, from the Eastern Mediterranean to East Asia. During the European Middle Ages, international law was concerned primarily with the purpose and legitimacy of war, seeking to determine what constituted a just war. For example, the theory of armistice held the nation that caused unwarranted war could not enjoy the right to obtain or conquer trophies that were legitimate at the time. The Greco-Roman concept of natural law was combined with religious principles by Jewish philosopher Moses Maimonides, that is 1135 to 1204, and Christian theologian Thomas Aquinas, that is 1225 to 1274, to create the new discipline of the law of nations, which, unlike its eponymous Roman predecessor, applied natural law to relations between states. In Islam, a similar framework was developed wherein the law of nations were derived in part from the principles and rules set forth in treaties with non-Muslims. Further, during the 15th century, there was an accelerated development of international law, which was very similar to its current framework. The influx of Greek scholars from the collapsing Byzantine Empire, along with the introduction of the printing press, spurred the development of science, humanism, and notions of individual rights. Now, increased navigation and exploration of Europeans challenged scholars to devise conceptual framework for relations with different peoples and cultures. The formation of centralized states such as Spain and France brought more wealth, ambition, and trade, which in turn required increasingly more sophisticated rules and regulations. In addition to this, the Dutch jurist Hugo Grotius, that is from 1583 to 1645, is widely regarded as the most seminal figure in international law, being one of the first scholars to articulate an international order that consists of a society of states governed not by force or warfare but by actual laws, mutual agreements and customs. Grotius secularized international law and organized it into a comprehensive system. His 1625 work De Jure Belli et Pacis on the law of war and peace laid down a system of principles of natural law that bind all nations regardless of local custom or law. He also emphasized the freedom of the high seas, which was not only relevant to the growing number of European states exploring and colonizing the world, but remains a cornerstone of international law today. However, the modern study of international law would not begin until the early 19th century. The 16th century scholars Gentili, Victoria and Grotius laid the foundations and are widely regarded as the fathers of international law. Positivism reached its peak in the late 19th century and its influence began to wane following the unprecedented bloodshed of the First World War, which spurred the creation of international organizations such as the League of Nations, founded in 1919 to safeguard peace and security. International law began to incorporate more naturalist notions such as self-determination and human rights. Now, the Second World War accelerated the development, leading to the establishment of the United Nations, whose charter enshrined principles such as non-aggression, non-intervention, and collective security. A more robust international legal order followed, which was buttressed by institutions such as the International Court of Justice and the United Nations Security Council, and by multilateral agreements such as the Genocide Convention. The International Law Commission, that is ILC, was established in 1947 to help develop, codify and strengthen international law. Moreover, international law became truly international in the 1960s and 1970s when rapid decolonization across the world resulted in the establishment of many new independent states. The varying political and economic interests and needs of those states, along with their diverse culture backgrounds, infused the hitherto European dominated principles and practices of international law with new influences. Moreover, international law became truly international in the 1960s and 1970s when rapid decolonization across the world resulted in the establishment of many new independent states. The varying political and economic interests and needs of these states, along with their diverse cultural backgrounds, infused the hitherto European dominated principles and practices of international law with new influences. The phenomenon of globalization, which has led to the rapid integration of the world in economic, political, and even cultural terms, presents one of the greatest challenges to the devising a truly international legal system. Now, the next question is, what are the sources of international law? So, the sources of international law applied to the community of nations are listed under Article 38 of the Statute of the International Court of Justice, which is considered authoritative in this regard. First, treaties, that is international treaties and conventions. Second is custom, that is international custom as derived from the general practice of states and International Court of Justice decisions. In addition to this, judicial decisions and the teachings of prominent international law scholars may be applied as subsidiary means for the determination of rules of law. Now let's discuss each of them in brief. First is international treaties. A treaty or international convention or charters refers to legally binding written agreements in which states agree and expressly and voluntarily accepted to act in a particular manner as specified in the agreement. The Vienna Convention on the Law of Treaties defines a treaty as treaty means an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments and whatever its particular designation. This definition has led case law to define a treaty as an international agreement that meets the following criteria. Criteria number 1, requirement of an agreement meetings of wills. Criteria number 2, requirement of being concluded between subjects of international law. This criterion excludes agreements signed between states and private corporations such as production sharing agreements. Criteria number 3, requirement to be governed by international law. Any agreement governed by any domestic law will not be considered a treaty. Criteria number 4, no requirement of instrument. A treaty can be embodied in a single instrument or in two or more related instruments. This is best exemplified in exchange of letters. Criteria number 5, no requirement of designation. The designation of the treaty, whether it is a convention, pact, or agreement, has no impact on the qualification of said agreement as being a treaty. Now, unwritten criterion. Requirement for the agreement to produce legal effect. This unwritten criterion is meant to exclude agreements which fulfill the above listed conditions but are not meant to produce legal effect, such as memoranda of understanding. When there are disputes about the exact meaning and application of national laws, it is the responsibility of the courts to decide what the law means. In international law, interpretation is within the domain of the states concerned, but may also be conferred on judicial bodies such as the International Court of Justice by the terms of the treaties or by consent of the parties. Thus, while it is generally the responsibility of states to interpret the law for themselves, the process of diplomacy and availability of supranational judicial organs routinely provides assistance to that end. Now let's move on international custom. Customary international law is derived from the consistent practice of states accompanied by opinio juris, that is the conviction of states that the consistent practice is required by a legal obligation. Judgments of international tribunals as well as scholarly works have traditionally been looked to as persuasive sources for custom in addition to direct evidence of state behavior. Attempts to codify customary international law picked up momentum after the Second World War with the formation of the International Law Commission, that is ILC, under the aegis of the UN. Codified customary law is made the binding interpretation of the underlying custom by agreement through treaty. Now let's move on third and last source, that is International Court of Justice ICJ decisions. Article 59 of the Statute of the ICJ states that decisions of the ICJ have no binding force except on the parties to the dispute. However, the ICJ tends to examine its previous decisions, determine which cases should not be applied, and really departs from the relevant case law. Now let's discuss the types of international law. So primarily international law categorized as public international law and private international law. The law that regulates the relations between two states is known as public international law. Public international law that regulates the conduct of one state with another is not concerned with the relations between private entities, that is, legal and natural persons, and even the domestic laws of any country. Now, the primary objective of public international law is to provide for a framework of rules and regulations which help in fostering stable and organized international relations. Some key areas where public international law is applicable are peace and security trade, weapons, international crimes, human rights, intellectual property, biodiversity, climate change, finance, development, science and security, extradition. Airspace, sea, fisheries and natural resources. On the other hand, private international law, often referred to as conflict of laws, is a set of rules and principles that govern interstate interactions and transactions of private parties. It is a body constituted of conventions, model laws, domestic laws of states, and secondary legal sources. Now, there are certain international bodies which have been working towards harmonizing private laws of different countries and bringing uniformity in their application. The bodies include organizations such as the Hague Conference on Private International Law, the International Center on the Settlement of Investment Disputes, that is ICSID, the International Institute of Unification of Private Law, that is UNIDROIT, the United Nations Commissions for International Trade Law, that is UNCITRAL, UNCITRAL, and so on. So it is different from public international law, as the latter is a set of rules which governs the intercourse between nations through determining the rights and obligations of the governments of the nations, while the former comprises of certain rules and regulations which are established or agreed upon by private citizens from different nations who enter into transactions and that would govern them if a dispute were to arise. So guys, this is all for today. However, before I say bye-bye, let's have a quick revision what we have discussed in this video. So I have started with the meaning of international law, and then I move on to historical background of the development of international law, and then discuss the major sources of international law, which are treaties, international treaties and conventions. Second one is the custom, and third and last one is the International Court of Justice decisions. So that is all. See you guys in next video. Till then, bye bye.